This federal court has come to the decision to dismiss the appellant appeal and found that the appellant is guilty for money laundering and corruption and sentenced to 15 years of imprisonment and fined for 15 million ringgit.
Waalaikumsalam, Datuk. Assalamualaikum to all my privileges. I've just received a call from Datuk Sazali, our senior lawyer in our firm, with regards to his Facebook posting. So now I want you all to research a good reference to the cases and all provisions that is related to see whether his Facebook posting and comment is amounted to contempt of court. Good luck.
From the fact of the case, we know that Datuk Sazali had posted his dissatisfaction with the court's decision in his Facebook posting. So now, lead us to the issue of whether Datuk Sazali's impertinent statements in his Facebook posting amounted to a contempt of court or not, in particular, scandalizing the court. So to have a better understanding in this issue and its applicability principles in relation to the offence of scandalizing contempt to our present case, we have made reference to a case of PCP Construction Sdn Bhd against lead modulation. The reason the case of PCP Construction is made for our reference because the similarity of facts between the PCP Construction and also in the case of Datuk Sazali, because in PCP the posting made by the lawyer, which goes by the name of Arun Kasih in this case, was found to be of a contempt of court, in particular scandalizing the court. So in this court, the judges has set up a test which utilized an objective basis, which namely the real risk test, where this test is used to know whether the impertinent statements posted by lawyer Arun Kasih is scandalizing the court or not. So the test is where the impression formed by the ordinary reasonable readers of average intelligence towards the judiciary when they read those statements, and if calculated to impair or erode public confidence in the administration of justice, hence the court will view it as a contempt of court. To put it simply, if the public read those statements and they made an impression towards the judiciary that made that the public confidence towards the judiciary will be lesser, then it will be amounted to a contempt of court. So by using the real risk test, the court made some reference to the Arun Kasih statement, which the court take among the statements. Let's say here 6 days ago, I had complained to the Malaysian Anti-Corruption Agency about the irregularities in the lead modulation case. So the word irregularities here means that the word itself would give the public or the ordinary reasonable reader of average intelligence the impression that the conduct of the case was riddled with corruption. And next, the court had see and view the statements of unprecedented manner, even without an appeal here, as a word that would form an impression that the federal court has acted in breach of law, both substantive and also procedural. And next, the court also viewed the word or the impertinent statements of serious anomalies associated with the decision that warrant a report to the MACC for its due investigations. Has the court find that this statement, when read by the public, would form an impression that the federal court was corrupt in handling the case of PCP. So from the reference and statement made by Arun Kasih, we take the real risk test and measured the statements made by Datuk Sazali. which here is the statements such as "I know they were backed by the opposition." When the word is used here, has actually give the public an impression that the judiciary in giving the judgment of Dato' Arun's case is corrupted by the desire of money. And another statement that we find from referring to the Arun Kasi case is when Dato' Sazali posted, "They are jealous of my client, so the judgment must have been biased." So the word here, when referred to the Arun Kasi and the real risk test, is when read by the reasonable readers, which is the public, would form an impression that the judiciary had on purpose given the judgment not favourable to Dato' Arun. So with reference to the referred case with PCP construction, and after applying the objective test, we conclude that it is apparent that the impertinent statement posted in Dato' Sazali's consisted of the statements that I've just mentioned before, amounted to the offence of scandalising contempt, since the impertinent statements, when it is read together, had give the public the impression that the judiciary has the existence of corruption. So there is another test that has been utilized in the case of PCP construction. So in utilizing the statements made by lawyer Arun Kasi in the articles, the court has used the mens rea test, which is the test whether Dato' Sazali Facebook posting was intentional or not. So we applied that test to Dato' Sazali's, and we could conclude that from the fact itself, the reason behind the posting of Dato' Sazali Facebook is because Dato' Sazali is dissatisfied with the decision made against his client. So, since Dato' Sazali is a senior partner in this firm, as such, he would or should have been aware of the impact and consequences of the impertinent statements he ought to have posted in his own Facebook. So, Dato' Sazali should have known that the statements will have the effect of undermining public confidence in the administration of justice. So, by referring to the referred case, we conclude that Dato' Sazali also fulfilled the mens rea test where he has intentionally posted the Facebook posting. So, to conclude whether Dato' Sazali's Facebook posting is amounted to a contempt of court or not, the posting had clearly stipulated the fact that Dato' Sazali fully intended for the content of his Facebook to be known to the public. So there is no other reasonable inference that can be drawn. And further, the posting is definitely not made within the limits of reasonable courtesy and good faith, since from the fact of the case, Dato' Sazali's conduct in taking matters by posting such statements was calculated to impair confidence in the federal court and thereby the judiciary system. Therefore, it is our finding that the statements posted by Dato' Sazali in his Facebook, taken in its entirety, and also the important statements, as we have used all the tasks, had clearly directed at the federal court and thereby the judiciary as a whole, as well as alleging that there is a corruption had been directed to the judiciary. Hence, we conclude, and it is our finding that the statement posted is indeed contemptuous.
Thank you, Ms. Aisha, for your opinion in regards to the whether Datuk Sazali's impertinent statement in his Facebook posting amounted to contempt of court. Consequently, following the posting made by Datuk Sazali that is indeed contemptuous, hence the liability of the comments published under the posting should be addressed to. Hence, on this matter, I will give my opinion in regard to this matter. Hence, the posting had gained the attention of the netizens, and from the perspective of the layman, they got the impression that Datuk Sazali is insinuating the judges and the judiciary system were corrupted. Among the comments received under the posting is by Note Nin Kompok, which stated that where is law and order in this country? Law of the jungle, better to defund the judiciary. Hence, the issue that we have to address here is whether Datuk Sazali should be held liable as the presumed publisher of the offending comments, even though the said comments were authored by third-party internet users, and Datuk Sazali was neither the direct author nor did they edit the comments. In dealing with this issue, I made reference to the case of Peguam Negara Malaysia against MKD.com, Sedia Berhad against another, which in this case, it contained the similar facts as the Datuk Sazali case. And in this case, Malaysia kini admitted that the comments are indeed offensive, inappropriate, disrespectful and contemptuous, and they also regretted the publication of them. However, they stated that they cannot be held liable for contempt because the comments were posted by third-party subscribers on Malaysia Kini website. And in short, they also contended that are not the maker. They are not the maker or publisher of the impertinent comments, nor did they have anything to do with the publication of them. Therefore, uh, they have no knowledge of the comments still alerted by the police. In this case, the author named Grey Deer 0609 comments under the posting in the website that kangaroo courts fully operational, Musa Aman 43 charges fully acquitted. What is law and order in this country? Law of the jungle? Better to define the judiciary. And the contemptuous nature of the offending comments was never in dispute in this case. As Malaysia Kini, as I said earlier, the Malaysia Kini has admitted from the very outset of the contempt proceedings that the comments are very offensive and contemptuous. In this case, the court agreed that with the AG that sections 114 of the Evidence Act 1950 applied in the above issue, in which the judge presumes that Malaysia Kini to be the publisher of the impertinent comments. And the court also rejected the basis that the Malaysia Kini have no knowledge about the comments. And the judge also further reiterates that Malaysia Kini is the owner of its website, which designs the website by themselves. Therefore, when they design the website by themselves, they have to control its online platforms in the way it chooses. Hence, it has full control. It has full control of what is publishable and what is not. Further, the judge stated in determining the existence of knowledge based on the surrounding facts of the case, Malaysia Kini was actually expected to have foreseen the kind of comments that will be attracted by the publication of the article on their website. Therefore, taking into the judgment in the earlier case, Datuk Sazali had published the contemptuous post through his own Facebook, which is one of the social media, that the owner of the account has full control over all activities in his own account. In earlier case, the posting made in website. However, in Datuk Sazali's case, the posting made through his own Facebook. Even websites owned by the companies can be controlled by the owner. And what's more, privately owned social media like Facebook in this case, which is in Datuk Sazali's case. Facebook has its own function that the owner can delete or hide any comments that are impertinent in their posting. Hence, when Datuk Sazali did not delete the comments that are impertinent in their when he did not delete the comments, he must carry with it the risk that follow from allowing the way its platform operates. Furthermore, Datuk Sazali, who was acting on behalf of Datuk Arun, who is a politician, should be expected to foresee this, that his postings would go viral and would attract more people even on his own Facebook, that eventually would cause the impertinent comments under his postings. To conclude, under the second issue, Datuk Sazali could not rely on the basis of not having the knowledge of the comments, where he should be expected to foresee this sort of comments given the case he was dealing with is a politician, and he could be found facilitating the publication of contemptuous comments by a third party. Therefore, as for a conclusion, Datuk Sazali could be guilty of contempt of court for being the presumed publisher of the offending comments. Next, for the next issue, I think I want to get the opinions from Miss Shafiqah.
Thank you, Miss Ain. Next, there is a further question arises with regards to the posting that had been made by Datuk Sazali, which is whether the act of contempt was that done by him is a crime or not. In contempt of court, there are two categories of contempt, which are criminal contempt and civil contempt. Firstly, criminal contempt is committed when the interference with the administration of justice is in the nature of a public wrong, like preventing a judge from giving judgment or threatening a process over a server that requires punishment from a public point of view, which is punitive in nature. This type of contempt has been categorized into four areas, which are contempt in the face of the court, scandalizing the court, prejudicing or impeding court proceedings, and interfering with the court of justice. As for civil contempt,
This offence is basically to compel obedience to the court orders and decrees which are given pursuant to a dispute between litigants. This contempt, also known as a contempt in procedure, as the punishment is remedial and it is beneficial for the complainant. With reference to the case of PCP construction, the court emphasized that the concept of freedom of speech in Article 10 of Federal Constitution is not absolute and still subject to some restrictions, which lying among them is contempt of court. However, the court is of opinion that contempt of court is not a very serious crime in this country, as may be the case as well. Based on the reasons stated above, even though Datuk Sazali's act amounts to contempt of court and he might get a punishment from his action, he still can practice as an associate and solicitor after that. This is based on the situation of lawyer Arun Kasi, where after he had been punished with imprisonment, he still could act as an advocate and solicitor. So, in order to know whether Datuk Sazali can be found guilty on his act, Ms. Nabilah will explain about this issue more.
Thank you, Ms. Shafiqah. So, based on the said posting of Datuk Sazali, we are of the opinion that there is a possibility that he will be cited and found guilty of contempt of court. This is because the said posting made by Datuk Sazali contradicts Rule 15 of Legal Profession, Practice and Ethics Rules. So, Rule 15 states that all advocates and solicitors shall maintain a respectful attitude towards the court. Nevertheless, as mentioned before by my other colleagues, his posting is likely to be categorized as scandalizing the court, conveying something other than or something contradicting than Rule 15. So by breaching Rule 15 of Legal Profession, Practice and Ethics Rules, Datuk Sazali had breached Section 94, Subsection 3 of Legal Profession Act as a part of misconduct, to which in Datuk Sazali case, he would be specifically be dealt under Subsection D, where the section provides that any misconduct is an act that breach any rules of practice and ethic, which in this case is Rule 15. So by breaching the said provisions with the Facebook posting, Datuk Sazali can be liable for misconduct on his part and he will be subjected to disciplinary action. However, this can only be made possible if there is a complaint made by Attorney General or by court itself. So, in the matter where the court may take action against scandalizing matter of Datuk Sazali, the court may make an order of committal based on any application from any party or the court's own motion itself, as stated in Order 52, Rule 2 of Rules of Court, to take action against Datuk Sazali's Facebook post. So, the power of the courts to punish the offence of contempt had been stated under Article 126 of Federal Constitution, Section 13 of the Court of Judicature Act, and also according to Item 26, Third Schedule of the Subordinate Court Act. So this section stated that judges starting from Magistrate Court until Federal Court are being granted discretion to utilize the rule of contempt that plays a significant role in the legal system. Hence, this order of committal allows wide discretion for the judge in exercising contempt jurisdiction. So, due to the possibility of misconduct as an advocate and solicitor, Datuk Sazali could be subjected to disciplinary action, which makes him unfit to be a member of his profession. Consequently, if in the event that he was found guilty of the said possible misconduct, provided under Section 94, Subsection 2 Legal Profession Act, he could be liable to be struck off the roll, which means that he is not a lawyer anymore, or suspended from practice for any period not exceeding 5 years, or being ordered to be fined not exceeding 50,000 ringgit. So nonetheless, if Datuk Sazali is found guilty of scandalizing the court, he is liable for contempt and the said penalties will be imposed on him. So I guess that's all from us. Thank you.